Hi everyone, good afternoon and welcome back to Thorough Newspaper Analysis. Today is 8th of July and this entire video series, it's brought to you by LawSikho. So now let's head to the agenda for today. The first segment for our discussion today would be the editorial segment, and here we talk about this article which is titled as Standing Up for National Anthem, what the Supreme Court has ruled. So as the title of this article itself expresses, we're going to talk about the law pertaining to the respect that is to be being paid on national anthem. Do we have to stand up mandatorily? Is it mandatory to play national anthem in cinema halls? Is it mandatory to sing along? What constitute an insult under the 1971 Act? All of these are going to be the point of discussions for today. Now, the second segment for our discussion would be the news update segment. And thirdly, we talk about important legal developments. With this, let's dive into the TNA, and this is going to be the point of discussion, the first point of discussion. So let's start with the why of this article first. See, very recently, an executive magistrate in Srinagar, he sent 11 men to jail after they denied to stand up or to rise up during the national anthem. So there was this event where the governor of Jammu and Kashmir, the lieutenant governor, he marked his presence, and there the national anthem was being played. There were certain people, some persons, they did not stand up, and as a result, the process of law it was initiated against them. So, with this background, let's address the very first question, the very core principle, which is the law pertaining to singing of the national anthem. And once we've done that, then let's come back to what happened in this particular matter, as in why these two sections of the CRPC were used very recently. So, if we talk about the legality governing this entire debate, for that purpose, first we address this decision of the Honorable Supreme Court, which is the 1986 case, wherein which is titled as Bijoy Emmanuel and others versus the state of Kerala and others. The second case law that we deal with is the 2018 Supreme Court order in the case of Sham Narayan Choksi versus the Union of India. We also talk about Section 3 of the 1971 Act, which is called the Prevention of Insults to National Honor Act. So, with this, let's start with the case of Bijoy Emmanuel. See, the law around alleged disrespect to national anthem, it was laid down by the Supreme Court by virtue of this decision in the year 1986. So what happened in this case was, the facts of the case are such that there were three children, three siblings, and they owed their allegiance to a particular sect of Christian. So they belonged to a particular Christian sect whereby they were permitted to worship only single God. Now the national anthem was being played in the school. They stood up, but they did not sing the national anthem along. So as a result, they were expelled from their school, and eventually the matter reached the Kerala High Court. Before the High Court, their parents they contended that since we belong to this particular sect where we are permitted to worship only single God, and national anthem is a form of a prayer only, so therefore our children they stood up to pay their respect, but they could not sing it. The Kerala High Court, however, did not grant them the relief that they wanted, and therefore the matter it eventually reached the Honorable Supreme Court. Before the Supreme Court, it said that forcing these children to sing the national anthem, it violated their fundamental right to religion under Article 25 of the Indian Constitution. Further, the court also held that the standing up respectfully when the national anthem it was being sung, which happened in this particular case, and not singing the national anthem themselves, it did not constitute an act of dishonor or an offense under Section 3 of the 1971 Act. So what does this section say? Let's talk about that now. See, this section essentially it prescribes a jail term of up to 3 years or fine or both. That is jail term of 3 years, the substantive jail term, and fine when there is intentional prevention of the singing of the national anthem, or there is intentional causation of disturbance by any person to any assembly that is engaged in such singing of national anthem. So from this particular provision, what we can gather is the law mandates or the law says that you commit an offense with respect to the singing of national anthem when you do two things. One is if you intentionally prevent the singing of the national anthem, or you disturb any assembly that is involved in the singing of the national anthem. Now let's test this section in light of this judgment in this case. So in this case, were these three children, were they disturbing the assembly, the others who were singing the national anthem? Did they intentionally prevent anybody from singing the national anthem? No, they did not. So therefore, the Supreme Court held that this section is not attracted in this particular case. And further, if we have a look at the 2018 decision of the Supreme Court, here two developments happened. First is in 2016, where in November of 2016, the Supreme Court passed interim order whereby it issued certain directives with respect to the singing of national anthem. Three of these directives are relevant for our purpose today, which said that national anthem shall mandatorily be played in the cinema halls before the screening of feature films. Also, it said that all the people who are present in the cinema hall, they have to be standed up. So they have to stand up. It is obliged, it is obligated on their part to do so while the national anthem is being played. It also held that or directed that the gates, the entry and the exit points of the hall, they are going to be closed while the national anthem is being sung, and also that on the screen of the movie theater, national flag is going to be displayed while the anthem is being played. However, later when the matter came up for next hearing in 2018, in January of 2018, the Supreme Court was apprised of the fact by the center that the center has constituted a 12-member inter-ministerial committee which is given the task of coming up with uniform guidelines to decide when the national anthem is to be mandated or on what occasions the national anthem is to be played or sung in theaters. So, taking cognizance of this update coming from the center, the Supreme Court modified its 2016 direction and held that now the playing of the national anthem in these theater halls, it is going to be optional and not mandatory. And also the Supreme Court now gave the discretion in the hands of the center government to deal with this entire matter. So this is the legal position so far as this entire issue is concerned. Now let's head back to the recent development. Here, a tweet was issued by the police department concerned, wherein it is stated that 12 persons have been generally bound down for good behavior under sections 107 read with section 151 of the CRPC. Now, section 107, what does it do is it empowers the executive magistrate to ask any person who is likely to commit a breach of peace, or who is likely to disturb the public tranquility, or who is likely to do any sort of any wrongful act which can procure these two results, which is the breach of peace or the disturbance to public tranquility. So the executive magistrate can ask such a person as to why, as to why he should not be ordered to execute a bond for keeping peace for about a year. The maximum period is 1 year. If we have a look at 151, so it says it empowers the police officer to arrest without warrant or without an order from a magistrate any person who is having a design to commit a cognizable offense. So this is an interesting provision because what's happening here is the offense, the cognizable offense has not been committed yet. But there is a design to commit a cognizable offense, and the police officer concerned is aware of this particular design. So therefore here the police is given the power to make an arrest without a warrant. So that's about these two sections. And with this, now we proceed to the next segment. And this has brought us to the national news category for today, with this being the first update. Indore Municipal Corporation, it has become the first urban body to get EPR credit. The Indore Municipal Corporation, it has become the first urban body in our country to receive the Extended Producer's Responsibility Credit. This is for the work of recycling 8 tons of banned single-use plastic items that were seized. So IMC, it collected the waste material and later recycled these collected material in a plant that is operated under the public partnership model, public-private partnership model. The government it has constituted a four-member group of ministers to study issues pertaining to Uniform Civil Code. This group of ministers it comprises union ministers who are Kiran Rijiju, we have Smriti Irani, Arjun Ram Meghwal, and we have C. Kishan Reddy. So while Rijiju, he has been tasked with the studying of issues related to tribal societies and their customs, Smriti Irani, the concerned minister for the Women and Child Development Ministry, she has been tasked to look at women-related issues. Law Minister Meghwal, he has been given the task of giving overall legal perspective to the debatable issues, while Kishan Reddy, he will peruse matters concerning northeastern states. Priyansh-Avneet pair, it wins junior mixed team archery gold. Indian archers Priyansh and Avneet Kaur, they've won gold in the junior mixed team compound event. They've secured this win, defeating their Israeli counterpart in the final of the World Archery Youth Championships conducted in Ireland. It was a nail-biting contest wherein the Indian players they beat their Israeli counterparts with a very close score of 146 to 144. India's Manav Jadhav and Aishwarya Sharma, they also won a bronze medal defeating their Mexican counterpart in the cadet mixed compound event. Cabinet has cleared the draft data protection bill. The bill it has kept all the provisions of the last draft that was released for consultation in November, but has now proposed a lower penalty for data breaches. So if we have a look at the penalty structure existing now, a penalty of up to rupees 250 crore it will be imposed both on data fiduciaries and data processors for breach of data in their possession. They will also be fined rupees 200 crore fine if they fail to inform the owners of the data or the proposed data protection board of the breach. All online and offline data in India they will fall under its legal domain. So this update is with respect to the bill being cleared by the Union Cabinet, and it is now likely to be tabled before the Parliament in the upcoming monsoon session. IPL version of Impact Player Rule in Syed Mushtaq Ali Trophy. The IPL version of the much talked about Impact Player Rule, it will be used in the Syed Mushtaq Ali T20 Trophy beginning October 16. This has been approved by the BCCI very recently, in fact yesterday. The impact player, it was introduced in this particular trophy last season, but it had to be brought before the end of the 14th over, and also it had to be named before the toss. However, this will change from the next season. So like IPL, the teams will be allowed to name four substitutes besides the playing 11 before the toss. Out of the four substitutes, only one can be used as an impact player. Impact player, it was used widely by 10 IPL teams, but the introduction of it has divided opinions. Jammu and Kashmir, it launches India's first chatbot for people in mental distress. The Telemanas chatbot, the first of its kind in India, it was introduced by Jammu and Kashmir in Jammu and Kashmir on 5th of July in a key step towards enhancing mental health support system. This creative project it attempts to offer fast help and chats to people who are in need. The availability of professional psychologists, health counselors and consultants around the clock, it means that this chat box will have a big impact on tackling the very tremendous and the big problem pertaining to mental health that we have generally and also in the area in Jammu and Kashmir. Justice Goel, he retires as NGT Chief. Justice Adarsh Kumar Goel, the chairperson of the National Green Tribunal, he was appointed in July 2018. He has completed his term on Thursday. Justice Goel, he is a former judge of the Honorable Supreme Court of India. During his tenure as the chief of the NGT, the NGT has witnessed numerous significant developments and initiatives. So under his able leadership, the NGT made notable strides in safeguarding the environment and in upholding environmental justice. If we have a look at the disposal of cases, the number of it, in the last 5 years, NGT it disposed around 16,042 cases. This has brought us to the international segment for today. Iceland, it is the most peaceful country in the world. The 2023 Global Peace Index, it recently released its annual ranking of the most peaceful countries in the world, put out by the Institute for Economics and Peace. The 17th edition of this index, it ranked 163 independent states and territories according to their level of peacefulness. The GPI covers 163 countries, comprising 99.7% of the world's population, using 23 qualitative and quantitative indicators from highly respected sources. So, if we have a look at the parameters or the domains on which these measurements are done, so it measures the state of peace across three domains. First is societal safety and the security standards. Second, the ongoing domestic and international conflict. And thirdly, militarization. And this has brought us to the last segment for today, where we take up for our discussion an update coming from the Honorable Apex Court in the case of Pratibha Manchanda versus the state of Haryana. So the Supreme Court, it has observed in this particular matter, while dealing with anticipatory bail applications, that courts must also consider the gravity of the offence, the impact on society, and the need for a fair and free investigation while the courts are dealing with anticipatory bail applications. So this has been the observation of the Supreme Court, that whenever the courts they are dealing with anticipatory bail applications, then they have to consider the gravity of the offense involved, the impact on the society that the offender has created by virtue of sort of inflicting that offense on the society, and thirdly, the need for a fair and free investigation. While it is extremely important to protect the personal liberty of a person, it is equally incumbent to analyze the seriousness of the offense and to determine if there is a need for custodial interrogation. This is what has been said by the division bench. And this has brought us to an end of the TNA. In case you want to get access to the free study materials that LawSikho provides or the TNA slides that have been used in this video, please feel free to join our Telegram channel, and for the very same purpose, you may scan the barcode here or click on the link which is given in the description. These are the point of contacts in case you want to get in touch with LawSikho. Also, the quiz based on yesterday's TNA, it is made available for your kind consideration in the description of this video itself. Please go ahead and attempt the same. Thank you for being with us.